All right. All right. All right. Good morning, everyone. It's Thursday, March 16th, 2023, and this is the meeting of the California Fair Political Practices Commission. Ms. Lincoln, would you please call the roll?
Commissioner Baker. Here. Commissioner Wilson.
Here.
Commissioner Wood.
Here.
Chair Maddox.
Present. All right. Good morning, everyone. We'll begin with item 1, that is public comment for items not on today's agenda. Do we have any public comment for things not on today's agenda? Hearing and seeing none, we'll proceed to item 2. That's our closed session, discussion of pending litigation. The commission will now recess into closed session and reconvene shortly. All right, we'll go ahead and reconvene. We've completed our closed session, which was item 2 with no reportable action. So we'll now continue with our agenda. We'll move on to item 3 as approval of the February 2023 commission hearing minutes. Do any commissioners have edits or comments on the minutes? Hearing and seeing none. Is there any public comment on item 3? Hearing and seeing none. Do we have a motion to approve the minutes?
Move to approve.
I will second. Ms. Linker.
Commissioner Baker,
Aye.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Match.
Aye.
The motion passes.
All right, we'll then proceed to our consent calendar. Today we have 2 items, items 4 and 5, both enforcement matters. Do any commissioners wish to pull an item from the consent calendar for separate discussion? Commissioner Baker?
Yes, I would pull both 4 and 5.
Okay.
Thank you.
So we're just going to go ahead and take those separately, one at a time. Welcome to the dais, Acting Chief Burton.
Good morning, Chair and Commissioners.
Let's go ahead and begin with item 4. Do you have any opening comments or things you want to draw our attention to?
I do not have any opening comments. I'm more than happy to answer the questions of the Commission.
All right, thank you. Commissioner Baker, did you want to begin?
Thank you. I only had 2 areas that just wanted to visit about somewhat of process. There is a streamline matter related, I believe, to the same campaign committee that was at issue in this. Although it's not mentioned, we go through the factors, other experience with FPPC enforcement. Is that a reason because either the timing of the stipulation with respect to the streamline matter, or is it because as part of streamline we don't mention that? Because it is one of the factors that is important, especially when you have a member of the legislature who's been there many years and has served in a capacity where they should be familiar with the act.
Right. I appreciate your question. We do have, there is another streamline matter. It involves the same candidate, although different committees. And in terms of looking at streamline and the factors, when we look to prior enforcement history, which I think might be what you're referring to, because these were essentially happened at the same time, we don't look at that as prior history. I guess if they were staggered and maybe one happened 4 years ago and the next one happened 4 years later, then we would look at that as prior history. But because they were essentially occurring simultaneously, so to speak, it's not viewed as prior history. Understood.
Thank you. And I don't know if, I don't think this would be a policy change. It would probably be more along the lines of what's the sophistication of the respondent, what's their experience with the act. As a member of the commission, I would always find useful to know that. I realize every word of a stipulation is negotiated. It's a minor point for here. It doesn't affect my opinion of the stipulation itself, but as future goes on, that's something that's helpful to know because it is just touching on what this person's connection is with compliance with the act. And it might be also a rare instance where they're so close in time that it wouldn't really be in there. The second is, I pulled the comparable that is cited here and actually went back and tried to look at the minutes from that time. Those days our minutes were much more skeletal, so there wasn't much substantive discussion, and asked if there were any others, if there were any advice letter, and I was very grateful for the response from our team, but I'm surprised that there's really very little on this. The issue of a candidate who has a controlled ballot committee and how they use it. Is that a function of we don't have many enforcement matters that comes up, or again, it doesn't go to this so much substantively, but I was surprised at how few comparables there were. If this just doesn't come up, or is it really an issue with respect to the fact that it's a regulation versus statute? I just open that up for you.
Sure. No, I appreciate that question as well. I don't want to speculate too much about that, but when in response to your question, I can think of the fact that this regulation is fairly young. It was passed in 2009, but you're right that generally we have not seen many enforcement matters involving this regulation over time. But again, I don't want to speculate as to why that might be. But the first thing that comes to mind is just simply that it's sort of a newer regulation that was promulgated by the Commission.
Yeah. Well, I appreciate that. I suppose I said I had 2 questions. I guess the third, and I'll have this with the next one as well. There's a statement that's often made in our STIPs that this matter did not reveal evidence indicating there was an intent to conceal, deceive, or mislead. And it's on page 5. When you have someone who has been in elected office for many years and presumably therefore has training on it and has familiarity with it, can you elaborate on how you come to a conclusion like that there's no evidence to conceal, maybe, and that it's maybe more negligent? Is finding a negligent to be more likely, and you really have to look for more for intent to conceal? I know we've seen stipulations where there's been much more clear evidence of someone who is trying to go around the law.
Sure.
How do you reach that conclusion, or how do you approach that when you have a situation where someone's a multiple year office holder?
I think it depends on the type of case. I think in this instance, attempt to conceal maybe is looked at a little differently because he's produced an advertisement that he's featured in, and the only associated activity would be the expenditures related to that, which were reported by the committee. But I think unlike let's say an advertising disclaimer violation or failure to report, I mean those are I guess clear examples where there could be an intent to conceal accompanying that type of violation. This type of violation is a little different in that respect, but so I think it really is a case by case basis in terms of how we look at that in the context of an investigation and in terms of what investigative steps to take to try and flesh that out.
Yeah, that's a good point. Just the nature of the particular case, how would you even conceal it when they've done the reporting? Well, thank you. Those were some of the questions I had stemming from this particular stipulation. No further questions. Thank you.
Thank you. Any other questions for Mr. Burton on item 4? Commissioner Wood?
This is not going to be well formed. Sorry. Hi.
Hello. Good morning.
Thank you for to the staff or whoever worked on the public harm piece. I thought that was really it's like much fuller this time, and I thought I learned from it. I wonder in these cases, and this is, I don't know, maybe this is kind of galaxy brain stuff, but my class and I have been talking about whether these committees have any duty to the donors. I mean, they're not really corporations, right? So we can't really read in kind of duties of loyalty and duties of care and things like that. But I did wonder if part of the motivation behind having this rule is to actually protect donor intent, right? If they intended to donate for a ballot initiative and then it ends up supporting a candidate, So anyway, I don't know if we have any information on that, but I would be really kind of generally curious about it. But also I wonder if it's something that we should start talking about. I mean, we had all these fraudulent kind of super PAC type things happening nationwide a few years ago, and it gave rise to that issue. So anyway, this gave me kind of a platform to at least float that out there. I don't know that it needs to go in this STIP or anything by any stretch, but.
Well, can I just?
Yeah, please.
I think there's you're raising two separate issues.
Yeah.
I think the first one, if I'm understanding it correctly, is the intent behind this particular regulation. And so I think to the extent that Mr. Burton could help us understand the intent behind the regulation at issue in this stipulation, that's good for us to talk about today in talking about approving or not the stipulation. The bigger question about what are we doing, what could we be doing more to protect donor intent with respect to committees, I would actually propose that become a future agenda item for Mr. Bainbridge and other folks to brief us on more fully.
I agree with all that,
okay?
and I appreciate you forming my question much better.
Just
much more better.
All right, Mr. Burton.
Yeah, sure. Those are great questions. I in deciding to charge this violation in the statute, in terms of the analysis that we did go back and look at the regulation and the intent behind it and essentially the legislative history. Because as Commissioner Baker pointed out, there really is not much precedent yet for this regulation. And because it was from not that long ago, we were able to look at the staff memos associated with the presentation of that regulation. And essentially, this regulation was passed as a way to plug a hole that existed that allowed the ballot measure committees to circumvent the contribution limits, as well as the one campaign bank account rules as well. And so this regulation was done to essentially plug that hole. And in looking at the staff memos, it also was apparent that when they were looking at the types of activities to prohibit, that the support of candidate elections was delineated specifically as that purpose. And so, and that is what you see here in the activity involved in this stipulation itself.
So I had nothing to do with donor. Not to say it too broadly.
Not on the record that Mr. Burton, as I'm understanding you, not on the record that you're familiar with.
Correct. It's not. It's not.
Thanks.
You're welcome.
Commissioner Wilson? No. All right.
Excuse me.
I did have one just back and forth I want to engage with for a second, and that is, so the one, it kind of piggybacks off of what Commissioner Baker said and what Commissioner Wood has reminded us of, which is that these become comparables for future cases when we approve these stipulations. And so this is a circumstance where we only have one prior comparable. And as I understand that comparable, it involved a situation where the expenditure at issue, it was very clear, it was almost black or white, that the expenditure there was related to something that did not fall within permissible expenditures under the regulation. It was an issue ad, and the regulation clearly says you have to spend the money for these particular committees related to a state or local ballot measure. Is that a correct understanding of the comparable case?
Yes, based on my reading of the comparable case, just as in this case, it was clear that that was a impermissible use of ballot measure committee funds.
Here, the staff has determined that the violation was that the expenditure at issue, while it did this advertisement, they did discuss ballot measures. They discussed there were other facets of it which ran afoul of the regulation.
Yes, that's correct. The comparable case, the communications at issue there appeared to be 100% unrelated to ballot measures. Here, it was sort of a blending of two things. Whereas the ballot measure was addressed, there was also the featuring of the candidate and essentially some type of communication supporting his candidacy for governor, which was the election being less than 2 months away from the time that these advertisements were disseminated.
Were there other factors besides the timing that bore on staff's approach here? In
terms of the content of the ad, just the mere fact that the candidate was featured in the ad for the duration of the ad, I saw that as quite convincing. Also, the appearance of graphics that identified him as a candidate for governor. He verbally identified himself as a candidate for governor, as opposed to assembly member, which he was an incumbent for. So when we looked at the totality of that in conjunction with the ad itself, that's why we thought this was the right result to find a violation under this regulation.
Okay, and that's the part that I just wanted to make sure I'm highlighting. Is this is a case where it was a totality of factors that led staff to conclude the regulation had been violated, as opposed to in the comparable case, it wasn't really a totality of factors. It simply was you spent this on absolutely, unequivocally, the wrong type of advertisement under this regulation, right?
Yes, and the citation to that comparable case, in part, was because it was the only one we had at the time.
Yeah.
It is certainly helpful, but that definitely drove why that case was included as a comparable to help inform the commission on that issue.
Okay, cool. I just wanted to make sure I was clear about that in my understanding at this point. Yep, Commissioner Baker.
Yes, it's a great question. Is there anywhere where that totality of the circumstances approach is that in the regulation
I don't.
or the statute?
No, it's not. But in just looking at the advertisement itself and the different characteristics of it, it seemed clear to us that the expenditures were not related to ballot measures only. And if you were to look at the exact language of the regulation, it is clear that, in fact, I can read it for you.
Yeah.
In fact, I have a slide that has it as well. If Elwin would be able to put that up, I think that might be helpful as well.
Thank you.
The regulation itself was not quoted in the stipulation. It was paraphrased. So perhaps it's helpful just to take a look at it here. But it does provide that committee funds must be used only to make expenditures related to measures. And so when you had a communication here that was using committee funds for something other than that, which was delving into advocacy for the candidate's election. That's why this would be a violation of the regulation.
Okay, and the advocacy was that the candidate appeared and there was a text. I can't remember what it says in the stipulations. There, candidate for governor, Travis Allen for governor, for an
Right.
amount of time during that ad.
Correct. And admittedly, it's a little difficult without seeing the ad itself, and
Yeah.
we have this problem with stipulations sometimes. But yes, he referenced himself as candidate for governor. Again, he could have referenced himself as assembly member. A graphic stating Travis Allen for governor appeared at the beginning of the ad for about 6 seconds. He also highlighted some of his accomplishments in terms of the gas tax. And again, the fact that he was featured in the ad for the entirety of the ad, which I don't know if that necessarily needed to occur. When we looked at all of that, it was clear to us that this was an impermissible use of those ballot measure committee funds.
Gotcha.
Anything further?
Thank you. No.
All right. Anything further? All right. I think that the penalty amount that staff has proposed here is appropriate. I think staff's approach at looking at the totality of circumstances here and determining a violation was also appropriate. So I'm going to move for adoption of item 4. Is there a second?
I'll second.
All right. Is there any public comment on item 4 before we proceed to a vote? Hearing and seeing none. Ms. Linker.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Maddox?
Aye.
The motion passes.
All right, very good. Let's go ahead and proceed to item 5. Mr. Burton, again, I'll ask you, do you have any opening comments or whatnot that you want to provide to the commission?
I just have a brief comment. I wanted to identify a small typo that was discovered in the stipulation. If you were to look to page 5, line 8, in terms of the law, the section regarding the law regarding advertising, at the end of line 8, instead of the word, at the very end of that line, instead of the word of, it should be the word or. But I did want to point that out for the commission, and I'm happy to answer any questions that you have on the stipulation.
All right. Thank you, Mr. Burton. Commissioner Baker, do you have questions?
Thank you. I appreciate that. Typos happen, so totally get it. The questions I had have to do with, first, on page 11, you have a discussion of the proposed penalty, and that this is one of the cases, and we haven't seen them that often, that first paragraph there, where because the requirement to disclose a top contributor was one of the allegations here, that the penalty can be much higher than our typical $1 or $5,000 per count. And again, this is a situation where we say there's no evidence to suggest omission was deliberate or there was intent to conceal the top contributor. I wanted to have you again elaborate on that with the extent to which you're allowed. I know we have to stay within the 4 corners because it is a significant issue when a top contributor, especially at least one of them, the CTA, which plays very actively in local school board races, very actively across the state of California, and has a lot of resources. And some folks see that and they say, oh, I want to vote that way accordingly. And others will say, no, that's something that's a flag for them. How you came to that conclusion with respect to not wanting to avail yourself of this higher penalty, that it wasn't intent to conceal. And is that the only factor that would make the top contributor higher penalty available here?
I appreciate your questions. So section 84.510 does give us the authority to charge a significantly higher amount, 3 times the cost of the advertisement. And it would apply to violations of the top contributor disclaimer statute, as well as the statute that requires you have a not authorized disclaimer as well, which was at issue in this case too. We've gotten some direction from the commission in recent years to take a look at 84.510 in conjunction with these cases and charge it where appropriate. And we have done that in a couple cases in recent years. However, that's been limited to egregious matters where it's clear that there was intent to conceal. And so we have we have used 84.510 in those situations. Here, we did not find this case to be one of those. It appeared clear to us that this was the case of a committee that was newly formed with unsophisticated individuals. They used treasurers who were not professional treasurers. I think they were simply affiliated with the committee. And also, which I think we look at as pretty heavily mitigating, is the fact that they disclosed these contributions on both 460s and 497s that were filed before the election. So that always is pretty impactful when we see that. Of course, we do take into consideration that these particular advertising violations have been called out as carrying a higher level of public harm. That's why they're in 84.510, and that's one of the factors why we chose max fine for these advertising counts, is we wanted to try and find that right balance between addressing the public harm, but not going with the 3 times the amount under 84.510, because based on direction from the commission and the other comparable cases, we've only used that when it's clear that there was intent to conceal. So those are some of the factors that went into play here.
That is helpful. I appreciate that the team has been aware of the feedback received from the commission in the last few years on intentional conduct. I really wanted to ask it particularly because there is a major political player involved in races, and just from a practical point of view, it's often very relevant information to the voter. They may have that information available on the 460 and other documents. For me, that is actually a mitigating factor. It's helpful to see that here. But this commissioner sees a distinction between those forms that are filed and what the voter is receiving. That's a very relevant contributor and player in the political world, for the good and for some voters, and for a word of caution for others. I think probably the deciding factor for me is that they did disclose it in other places. Now, if I remember correctly, there was a lot of delay in how they did this. Eventually, they got all their filings together after the FEBC contacted them. So were those filings, how far off from the election were they?
The filings that included that contribution were filed before the election.
Okay.
It was, I believe, the first pre-election statement and the corresponding Form 497, and those were filed before the June 2018 election.
So, my feedback is that is a very relevant point in this situation. Otherwise, I think I would have found myself veering more towards that top contributor increased penalty for the very reasons I've stated. So I appreciate that. And I do appreciate that in some of the other counts, they're maxed out, for sure. I think that's the end of my questions. I really wanted to focus on that issue. Thank you.
Thank you. I just want to clarify something, because I appreciate your point about the top contributors. I think we can just acknowledge there are some contributors who are more active than others at a larger level than others. Now, that is true across the spectrum. The law, as enacted by the legislature and the voters, doesn't say we only care about the top contributors who are of a particular size or how active they.
Right.
It is the top contributors who meet certain thresholds, period. And that is all that we care about here, as far as I can tell. And so, Mr. Burton, from the enforcement division standpoint, whether the missing top contributor is a highly active entity like CTA, or whether it's a new entity that just popped up yesterday, doesn't really matter for us in terms of enforcing the law, does it?
That's correct. We wouldn't consider necessarily the stature of the contributor themselves. If they, had a active role in the committee, then that's something we would look at as maybe in terms of intent and whatnot. But in terms of who that top contributor is, no, we would not consider their reputation or stature or anything like that.
Okay, I just wanted to.
Yeah,
I appreciate your point.
That's a great point. Yeah.
You have a good point, but
I
just
could
wanna make
list
sure
other
staff's
people
clear
too. Yeah.
about their marching orders are.
Yeah.
As well.
Yeah.
So, all right. Any other questions or comments on item 5? Commissioner Wilson, and then
Thank you, Mr. Burton. This is more of a kind of technical question. I know we have to stay within the 4 corners. And in this particular, stipulation, there was a conclusion that there was no intent to conceal. Is that correct?
That's correct.
Okay. So if there is an intent to conceal, could be the highest penalty?
We are able under section 84.510 to charge 3 times the cost of the advertisement.
Okay. Okay.
So it can be significant depending on the type of ad that's at issue.
All right. Thank you.
You're welcome.
Commissioner Wood?
I think I'm mostly just echoing Commissioner Baker, but and I think intent to conceal doesn't really distinguish between who we're intending to conceal it from, right? But if I go to my mailbox and see, an ad that doesn't have the major contributor information, then I, as a voter, have been deprived that information in a direct way, even though indirectly through media intermediaries and watchdog groups and opposing political opponents or whatever, I may eventually get the information. At the time I'm seeing the ad, I'm deprived of it. And so I don't think we really have I don't know. I guess I would be interested to know whether you think we have a pathway at all to start distinguishing between those two different types of concealment. Because what we're accepting as a lack of intent to conceal might better be defined as a lack of intent to conceal from the government via forms. But what it could also kind of less charitably be interpreted as is an intent to conceal at the time that the information is being kind of absorbed, the ad is being absorbed, or an intent to make the public work harder to get the information. You see what I'm saying? And so I don't know if you think there's a pathway to start kind of distinguishing between intents in that way, but I'd be interested.
With the direction of the commission, that's something we can start considering. I do think 84.510 already gives us a tool to be able to do that, at least as to these two specific types of disclaimers.
Commissioner Baker?
I want to make sure we're not, at least I am not mixing up concepts here. The top contributor requirement does not require, in order to use a higher penalty or seek one, does not require an intent to conceal, does it? There's no intent requirement behind it.
The statute does not specifically say that. That's just based off of direction that we've got from the commission over time in terms of when to use that, because the penalties are significantly higher than the $5,000 max fine that would otherwise be charged.
Well, I certainly respect that. Our feedback has been when there's intentional conduct, we would like to see a pursuing of we certainly would expect that in those cases. I don't know that that's the only time. At least this one commissioner would not think that's the only time you would seek a higher penalty. Maybe not treble, but higher penalties. So for me, if the law does not require an intent to conceal to pursue it, I don't think we should impose it as a requirement. We've given feedback that if there is intent, we definitely want that path to be pursued. And I just want to make that clear, that there are two different concepts for us. I don't know that I did make it clear. I sure hope I did. So, thank you, at least for my point.
Any other comments on item 5? All right. Any public comment on item 5? Hearing and seeing none. I think staff has, again, correctly balanced their approach here in terms of recommending the penalties, the 2,000 for counts 1 and 2, and then the maximum penalty for administrative fines of up to $5,000 for counts 3 to 6. So I'm going to recommend and move approval of item 5. Is there a second?
Second.
Ms. Linker.
Speaker. Can I interject quickly? Executive West Director West has clarified that 84.510 as amended in 2018.
It was amended a couple of years ago in order, the language making intentional violations only subject to the 3 times amount was added a couple of years ago. So this violation was 2018. So Mr. Burton was correct in what he was saying, but just so that the commission knows that was changed to be only intentional violations.
Okay.
Thank you. I think I voted for that. So thank you. Okay.
Thank you.
Ms. Linker, call the roll, please.
Commissioner Baker,
Aye.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Matich.
Aye.
The motion passes.
Thank you, Mr. Burton.
Thank you.
All right, we'll now proceed to our general items. We have items 6 through 11. We'll begin at item 6, and we will welcome to the table Commission Counsel Mr. Lewis. We'll be talking our pre-notice discussion of proposed amendments to Regulation 18531, return of excess contributions. Good morning, Mr. Lewis.
Good morning, Chair Matich and Commissioners. So as mentioned, I'm going to be speaking about proposed pre-notice changes to existing Regulation 18531, currently titled Return of Excessive Contributions. A little bit of background about this regulation. The existing regulation permits a committee that receives an over-the-limit contribution to return that contribution within 14 days without running foul of the contribution limits, so long as the committee doesn't deposit or allow deposit of the contribution with actual knowledge that it exceeded the contribution limit, and as long as the committee doesn't make use of that contribution prior to returning it. The existing regulation also defines the phrase makes use of as essentially making expenditures that exceed the committee's available cash balance had it not received over the limit contributions. It also spells out that in the case of a non-monetary contribution that exceeds the limits, that contribution may also be returned either in its original form or in a monetary equivalent without violating the contribution limits. Finally, subdivision F of the existing regulation requires that an over-the-limit contribution that is returned must be reported in full on the committee's campaign reports and statements, and that the returned contribution must be reported as an expenditure. Now, in September of last year, the legislature passed SB 794, adding a new section 85319.5, I'll refer to it as the statute going forward, to the Act. And the statute codifies portions of existing Regulation 18531, as well as directing the Commission to make some appropriate regulatory changes to effectuate those changes and some other minor changes. Specifically, subdivision A of the statute, the new statute, essentially codifies subdivisions A through B of the existing regulation, along with subdivision E of the statute, I should say, which addresses the definition of makes use of. But in addition to codifying the rule in the existing regulation that allows a committee to return a contribution without violating the contribution limits, the statute also permits a committee to attribute a portion thereof to a different election, in accordance with certain other provisions we'll talk about in a moment. And secondly, in the case of monetary contributions only, the statute goes a step further than the existing regulation in saying that a committee that even does have actual knowledge that the contribution exceeded the contribution limits may still avoid running afoul of those limits if the contribution is either returned or attributed within 72 hours as opposed to the 14-day limit in the existing regulation. Finally, another change made in statute, besides codifying portions of the existing regulation, is that the statute requires a committee that has to return or attribute such a contribution over the limits to inform the contributor that their contribution was over the limit, and also to inform them if it was attributed to another election, in which case the contributor may seek a refund. So, in response to these statutory changes, staff recommends 6 substantive changes to the existing regulation 18531. First, as I think I alluded to, because the statute essentially codifies subdivision A and B of the existing regulation, staff is recommending deleting subdivisions A and B of the existing regulation because they're duplicative of what's now in statute. And secondly, we recommend adding a new subdivision A, and this would spell out the rule under the statute that a committee may attribute in writing a portion of an over-the-limit contribution to a different election, including that in the case of a committee wanting to attribute an over-the-limit contribution, a portion thereof, simply between the primary and general election, they may do so automatically without requesting permission from the contributor. They still have to notify them, but there's no permission required. A third, staff recommends adding a new subdivision B to the regulation, which addresses the return and, or I should say, attribution of over-the-limit non-monetary contributions. Subdivision A of the statute speaks broadly of contributions, whereas subdivision B of the statute specifically pertains to monetary contributions. And so to be clear, new subdivision B of the regulation would address the return or attribution of over-the-limit non-monetary contributions. And correspondingly, we're recommending deleting existing subdivision C of the existing regulation and moving those provisions into the new B. Fourth, we recommend adding new language to existing F, which again just spells out the requirement that a contribution that is attributed per the new statute has to be reported in full on the committee's campaign statements and reports, and that the portion attributed to another election counts as an expenditure, or is reported as an expenditure, rather. Fifth, we recommend adding a new subdivision defining this actual knowledge standard that the statute differentiates between, and in a way that's slightly different from the existing regulation. And we recommend that actual knowledge be defined as either accepting a check on its face, or I should say as the following, but perhaps not limited to: accepting a check on its face that exceeds the applicable contribution limit, or receiving an electronic payment which on its own or when aggregated with other payments from the same source exceeds the contribution limit and was made in response to a solicitation. Finally, the last subdivision that we recommend adding clarifies that a committee that receives a contribution over the limit must notify the contributor that their contribution was in excess of the contribution limits. In other words, this fleshes out the new notification requirements in the statute, including putting a point on the fact that where a committee notifies a contributor that its contribution both is in excess of the contribution limit and they want to attribute a portion thereof, those two notifications have to be sent to the contributor at the same time. So that concludes my overview of the proposed changes, and I'm happy to answer any questions you may have about those or the statute or both.
Thank you, Mr. Lewis. Do commissioners have questions for Mr. Lewis on item 6? Okay.
Thank you. Thanks, great briefing, understanding on this. So one question I had is going to something I guess I'll work backward from how we were going here. You mentioned check in subsection F, which I think in our materials is page 3. First of all, you mentioned maybe you're thinking that it's should be this, but not limited to, which of course the language doesn't say that. So that might be something you want to tease out a little bit. But with a check, I'm old fashioned. I remember the days when there'd be a remit envelope. It doesn't have a check in it, but the donor could put their Visa number and their signature on it, authorizing your treasurer to do that. But that's your written point. I know that the next subsection says electronic payment. I just want to make sure we're capturing what all happens. And I assume with what you're getting at with check is what we can visually see. They're somehow receiving a check. But given the old-fashioned description that I just gave you, which I have no idea if people still do that, a remit envelope that allows that. There's no check in it, and it's not like an electronic payment, like it hasn't been done on their website, for example. Just want to make sure we capture that scenario. Other ways in which the information that can go above the contribution is given that doesn't, I think, fit the definition of electronic payment or check. And that's the one example that I have.
Yeah, that is a really good example. And in fact, since drafting this language, I think we have been thinking about the fact that there are a number of different ways to structure this. I think just so you know, Commissioner, the intent here is to try and, like you said, capture the different analogs of receiving a check that on its face is over the contribution limit. So I think we're quite open to tinkering with this language so that we can make sure to capture all different kinds of permutations, both physical and electronic. And thank you for raising that, because I had not thought of other physical examples other than receiving a check on its face, and was thinking more of different electronic possibilities, but I think we need to look at both.
Yeah, I don't know if that would be saying written or electronic payment.
Mm-hmm.
If it would just be payment. So sounds like you're hot on the trail, and that's just one example. Again, I have no idea if people even still do remit envelopes and have that option, but old-fashioned as I am, I know they still can. My next question goes to the previous page and the provision where the excess can be made in a contribution to a subsequent election. Is that language, the a subsequent election, is that in the statute? Are there any other parameters that the statute provides for what that means? Because that is quite broad. It doesn't say the next election. It doesn't say for this time, but for a subsequent election. And if that's the language of the statute, it's helpful to know. I don't actually have it.
Which
I'm
section
sorry.
of the reg are you pointing
I apologize. It is 18531B on our materials, page 2, line 2 to 3. It's also in the memo. Oh yeah, okay. Yeah, it's in the memorandum. That statute language isn't super handy. It's in the memorandum at page, well, there's no page number. Page 5. So it says it's my duty to be prepared. I don't have a copy of the statute in front of me, but I am sensitive to if we're being just as broad and have the same scope that the statute has. And you address that.
Yeah, thank you for that question. That's also a really good observation, because I'm now looking at that phrase in our draft amendments to the regulation. We say subsequent election. And I think the original phrase in statute, so this would be in section 85319.5A, A and B, is another election. And so I think that's another important term to flesh out. I think based on past advice, our understanding, or our thinking, I should say, was that meant subsequent election. I think that might have been why we drafted it the way it did. But
even subsequent election, there's definitions of what subsequent means. If it has a or the, but if the statute says, I apologize, I interrupted you, but the statute says another election, I think that needs to be looked at.
Mhm.
don't want to go too far from where the statute is and set ourselves up for any issues.
Yeah, I agree.
I'll leave that one with you. I'm just bringing problems. I'm not coming up with
No, this is
solutions.
helpful.
So,
Yeah, well, to that point, I mean, on page 2 of the regs, line 1, you use the phrase "a different election." So I think to
Mhm.
Commissioner Baker's point, I would recommend picking one to the extent we can, and maybe just use the term from the statute to be safe. And then if we think we need to define that further, then we can have that discussion.
Yeah.
Seems like another election is pretty clear on its face. It is without limitation, it seems like.
Yeah.
But I leave it to staff to decide whether we need to define that some way.
yeah, it does seem pretty broad. So if you do come back with recommendations, I can anticipate my questions will be, what's the statutory authority? What's the basis? What's our legal authority to do it that way? My third one has to do with the practice now. If someone gives, let's say it's a husband and wife sign the check, spouses or people who are joint account holders, sign a check that's the equivalent of a double maximum. They sign it in the primary. I'm just wondering how we're consistent with what we do now when a check comes to a campaign that is over the amount that doesn't fit into the scenarios that you gave, which is if there's two people, maybe it's attributed to both of them, or when the spillover, I call it spillover, goes from the primary to the general. Because I think there are some other scenarios that aren't captured here in the memo, and I just want to be consistent with what we do elsewhere. And certainly elsewhere, I don't think there is a written notification. You're not proposing one if it's from the primary to the general. But can you address that if I haven't asked it too vaguely?
No, not at all. It's my understanding, again, based on previous advice, but I think further research is warranted, that it is common practice that committees will split such a contribution between the primary and the general. Whether or not that is in conflict with this phrase, another election, I think is something I'd want to do further research on to be sure that we're consistent and again look more deeply at previous advice.
Yes, and the and how this is different. And maybe when they wrote this, the legislature, they already knew that there's a practices in place based on advice or perhaps other areas of a statute that say, here's what you do with the check when it's this amount. There's this many people on the check. There's that many people on the account hold, all that. Because I do know there are circumstances where if somebody gives you over the amount in a primary, it can go to the general under existing law without much fuss and completely consistent with the law. So I'm asking a little bit different about the research on another election language. It is, what are our existing practices, and make sure therefore that we're capturing all of those scenarios. Thanks.
Commissioner Wilson?
Mr. Lewis, just in terms of kind of a technicality, as you're defining another election, and I'm making an assumption that you'll also be looking at this as well, that in addition to primary and general elections, there are also special elections. So you want to make, I think I'd recommend that we make sure we cover that scenario as well. Thank you.
Thank you for that.
Commissioner Wood?
In the spirit of no question is a dumb question, I'm a little concerned that I might be asking a dumb question, but the statute doesn't say that it has to be transferred to another committee for another election. It doesn't say anything about that, the another committee part, but we have that in the regulation. And I guess I know, like, some committees, like outside groups, I know just from my research, they persist over time. I would assume candidate committees can do that too, right? Through election cycles. So if I'm an incumbent, I kind of have that war chest that I can use for the next election, right? And so I don't know that we need the attribution to happen to another committee, do we? Because the statute, I don't know if it requires it.
So I think that depends on a number of things. If an incumbent, for example, is is going to be running for another office. I mean, that's an example of where that would not be permissible. So I think we'd have to look at each case. But so your general question is, if a candidate receives, has leftover funds, can those leftover funds be used toward?
Well, I know that,
Okay.
right? But it's more like if you give me a big contribution, can I attribute some of it to the next election cycle for my same seat if I'm an incumbent and I plan to run again? Because if so, this language I don't think would allow it, because it says to another committee. If I don't plan to close my committee and then reestablish a committee, but just to keep my same committee. But the reason it feels like a dumb question is I don't know what candidates do here in California.
Yeah, can Mr. Bainbridge just hop in real quick and just give us a primer on that,
Thanks, sorry.
please?
Yeah, no problem. State candidates for each election cycle have to open a new committee.
Thank you.
And local candidates that are subject to the state limit.
Okay.
So many committees have to transfer to a new committee, and they transfer it all over in bulk typically. It's really only on paper, but it is technically a new committee.
Okay, so then this is right. This is the way this has to happen.
Yes.
Okay.
Yeah, so
Thank you. Sorry about that.
I think there is no other way to transfer it but for there being a committee to receive it, is what you're saying.
Right. And my recollection of the legislative intent was that it include subsequent elections, not just from a primary to a general.
But if I'm an incumbent facing a primary, I don't have to create a new committee for the general. I just, within my electoral cycle, I can use the same committee.
Correct.
Okay, thanks.
I have a question for you, Mr. Lewis. So going back to where Commissioner Baker went about, it's on page 3 of the regulations, subdivision F, right? And I know staff already plans to do a little bit more fine tuning with this provision, but just taking a step back, when we define what it means to have actual knowledge, I think what we're doing then is saying you need to take action within 3 days. You don't get the 14 days. That's the significance of the actual knowledge standard, right?
Correct.
So with respect to a physical check, you receive it, you open the envelope, you know in that moment it's over the limit, 3 days, right? I can understand that. And the remit envelope, similar thing, right? Electronic payments. Because I think on the one hand, I'm curious just how staff is envisioning this. Electronic payment, it's instantaneously appearing in the account. So in that sense, it's kind of analogous to somebody handing them a check. But then you have to assume that somebody is monitoring the account. And so if we, in F, said that receiving an over-the-limit electronic payment is actual knowledge, what is the standard for evaluating when somebody is charged with that knowledge? Right? Like how do we determine when that 3 days begins? Is it when they receive the bank statement? Is it like, what would we do under those circumstances?
Yeah, I think that's a good question. One simple approach would be to charge the treasurer with being responsible for having that knowledge once it's deposited. I think I think that would be consistent with their duties under the Act and with the contribution limits. And I should point out here that the object of the legislature here is really to create more leeway, in essence, for committees that find themselves in this situation and not punish them. And so really, we think that monitoring one's bank accounts, especially with various notification technologies and stuff that exist today, even when receiving contributions from fundraising platforms, those technologies could arguably make it easier to be notified when this happens than paper mail. So I don't think it's necessarily a burden merely because the payment it doesn't have to be a burden merely because a payment is made electronically versus physically.
Do we know whether that kind of technology, because I mean, look, like, when I think about it, what you're saying makes sense if we're talking about like, I don't know, my bank account, like my checking account, but we have to put this in context. Like this is going to apply to statewide candidate races where they are getting thousands and thousands of transactions potentially in a day. And so that's why I'm asking the question, because you have not proposed here treating electronic payments that are facially over the limit the same for purposes of the time frame to decide what to do, either return it or attribute it. And so on the one hand, I think that makes sense from a practical standpoint. And so what I was trying to get a sense for, as you go back and you look at this again, what your perspective on going the other direction would be. And I would suggest that we do some outreach if we decide to go in that direction, because I suspect that in practicality, that would be incredibly difficult and drive up costs, frankly, for these campaigns, if you were to impose that requirement. And so I just offer that as perspective when you're considering it. Yeah, Commissioner Baker.
I am so glad that you raised that issue. It's been 4 years since over 4 years since I was a candidate. But from, again, that long time ago, you can have electronic contributions coming in, dozens and dozens, if not hundreds, especially right before a reporting deadline. And a treasurer will have potentially multiple clients dealing with that. And 72 hours is a short period of time when you get that tidal wave of contributions to potentially have what is joint and several liability. Well, I guess this goes to actual knowledge, but yes, it can create a liability. And I had not picked up on that one, and I think it is important to look at again, what does the statute say should be our guiding principle? I know we're trying to fill in the blanks, but if the 72-hour period is appropriate for that, I'm also aware, I'm just adding, again, experience, there are software that, and it depends on which one a treasurer and a candidate pays for. The more expensive ones at the time were the ones that refused to accept a contribution from over the limit. Even if, let's say, this provision allows, that software is going to have to be rewritten now. And so there was that nice backstop. You also might have gotten an email to the treasurer and the candidate, or someone on their campaign if they so chose. You could have hundreds of emails coming in and miss one.
Yeah.
So I want to be mindful of human nature, even the most diligent folks, what is possible to monitor, and just add that additional background that's from over 4 years ago, so things really may have changed. And some candidates that are much more on shoestring, they may not use the software. They may just be pulling it together on their own with their friend who's a CPA, and they're going with the best they have as well. So thank you for proposing that additional outreach so that we really try to get this right. Thanks.
Other comments, questions?
Can I, on this topic?
Yes.
Since we're at pre-notice, I'd be interested, I think this is one of the major policy issues for the commission to consider. To give you the background, probably 3 years ago, we changed this regulation at the request of CPAA to account for the proliferation of electronic transmission of contributions. The previous rule was you can't deposit a contribution and return it. Once you deposited it, it was technically a violation. We had expanded that rule to allow committees to deposit it, but then return it within 14 days, with the acknowledgement that a lot of these contributions get deposited automatically now. They don't get a check to look at. And that was the 14-day rule, which we had in place for checks that you received but never deposited. We extended that to contributions you receive electronically. You could then have 14 days to return. So that's the background on how we got to here. During that presentation of the regulation, there was a long discussion by the commission about what actual knowledge was, which is what we were trying to capture here with this explanation. There was quite a few questions about, well, if I get a check that actually says $10,000 on it, do I have actual knowledge that that exceeds the contribution? With the acknowledgement that candidates aren't sitting there checking every check that comes into their committee. So they were expected to have actual knowledge of anything that was considered over the limit on its face. And that was the commission's the commission was adamant about that point at the time, that should be actual knowledge, even if the candidate's not the one who's doing their own books. So that's the issue here that we're trying to get at with defining actual knowledge. So in saying the commission has some room here to decide what actual knowledge means, but it would be helpful either at this meeting or at some later law and policy or some event to get the commission's perspective on which way they would like to know what they think is essentially assumed knowledge for the candidates of a contribution over the limit.
So I appreciate the reminder, but so when the commission had that discussion, actual knowledge was tied to a 14-day period of time, though.
Right, correct.
And so here, I mean, I appreciate that you're trying to incorporate our views on what actual knowledge meant then to what we're doing today. But there is, I think, a critical distinction, which is then it was in the context of giving somebody 14 days. And here it is now in the context of a 3-day time frame, right?
Right.
Okay. I just want to make sure that we're clear about that. It's not I don't see it as simple as just porting over an understanding from before. Like the ground has changed a bit.
Right, and that's why this is the starting point. And so if the commission feels differently, if they think how to define actual knowledge should be affected by how much time they have to return it, that's the sort of direction we would appreciate in bringing this back for adoption.
Yeah.
It's kind of an obvious question, but you talked in terms of actual knowledge. When there's an automatic deposit, what is your interpretation of the regulations that would be in play?
The draft that we have before the commission right now? Is that the question?
Yeah. Yes.
The way it's currently drafted, it would be if they solicited that contribution, they would be considered to have actual knowledge of a contribution that went in their account that was over the limit.
Even though it automatically went into the account, and they didn't have the actual knowledge of what that amount was, but they have 14 days to check the records. Is that the logic there?
Right, or 3 days in that situation
3 days.
to check the record. Yeah.
Could I just clarify something? Maybe this is me misunderstanding the discussion, but the existing regulation permits a committee to return a contribution within 14 days if there is not actual knowledge. So now, so I just want to clarify that it's not that previously the rule would be for committees with actual knowledge, they had 14 days, but rather in the absence of actual knowledge, they had 14 days. And so I guess I just wanted to clarify that, and that I don't think we're imposing a new requirement upon committees with actual knowledge, but trying to as General Counsel Bainbridge mentioned, just sussing out how the commission defined that previously. But obviously, I defer to the commission as to how you would like to define this. And I would note that if I read correctly, the statute doesn't direct the commission to define this term, unlike some of the other regulatory changes that it does fairly explicitly direct us to make. But that's up to your discretion, of course.
Thank you, Mr. Lewis. Appreciate that. I had one other question for you. Just curious. But so as I understand it, under the new statute and under our regulations, there is no requirement of getting permission from a donor to attribute an over-the-limit contribution to a general election, right? If it's received at the time it's primary, before the primary, and it's over the limit, you can just automatically, right? And so my question is there any requirement in our regulations or in the statute that would put donors on notice? Like, for example, let's say solicitations that are sent out. Are solicitations required to inform a donor that, by the way, we have the right to automatically attribute over limit contributions to a general election without your additional permission? Is there any way for the donor to know that? I'm just curious.
Yeah, that's a very good question. To my knowledge, there is no such requirement, but I'd have to double check this. Not something I've heard of before.
Okay, I was just curious.
Mm-hmm.
That's my random question for
today. I can report back on that.
I'm throwing a little local color on that again from ancient times. when I was a candidate. So solicited, it's very interesting to me, both what Council Bainbridge has said in response to Commissioner Dotson's question and what you just raised. Solicited, I'm sure we have it defined somewhere. I would think somewhere we have it, but you can send your email out to your donor list, and that a month later, somebody can get around to clicking the link. Or you can be at an event where you're asking people to give money, and a month later, somebody comes. I remember folks would say, I've had this remit on my dresser for months, and I finally got around to it. So I don't know where that definition, if we're going to start working that into how this plays out, I'm not trying to quibble at every turn here, but we need to be mindful. That's the practical implication, that it's not always in an immediate time frame, and which you probably already know. So I just want to add that part about solicitation. What is our definition of it elsewhere, and what's the practical, real implications of it? Yeah.
It's as if you were in our prep session. That's another issue we had identified.
sure it
That
was.
if we're going to go with that standard, we need to label it as a direct solicitation or some way explain what solicitation means.
And Mr. Chair, if I may, I want to say I did go back and watch the February, I think in the memo it said February 2020, this came up before. So I'm going off the freeway a little bit. I appreciate that that was in the memo so that we could go back and look and read those points to see where in time that was as part of our homework. So thank you. It didn't make me any smarter for how it all works out, but it was helpful to see how that came up.
Commissioner Wood, did you have your hand up too?
Well, I did, but I was going to talk about the definition of solicitation. And so you read my mind, and I guess we were reading their minds. So I was just thinking for actual knowledge. I mean, I just went back and found a definition of solicitation in the regs, and it doesn't talk about an amount, but if we're worried that that the 72 hours is too tight given the technology, I mean, it might be kind of difficult, from a regulatory perspective to do it this way, but you could have kind of a higher actual knowledge standard where the solicitation includes the amount or something. I mean, it would make it almost something we would never see, where we would kind of end up just doing the 14-day thing. But anyway.
Well, for my piece, I would just say I appreciate where staff is trying to go with that. And so, and we're on pre-no, so this is the time where we kind of just nitpick these things. It does strike me that we already have some issues in the behest of payment context, figuring out when payments are or are not actually responsive to a solicitation. And so I almost have it's no, not again. Are we setting ourselves up for something that is going to be very difficult to enforce? So I just offer that as food for thought as staff goes back and takes a look at this. Sometimes a simple approach that is easy to administer, easy to enforce is sometimes better. So
Definitely.
My 2 cents. Yeah. Commissioner Wood?
But simple and easy how? You know what I mean? Because the actual knowledge thing is always going to be hard. And so if solicitation's part of it, maybe you're saying don't make solicitation part of it.
That is precisely what I'm suggesting.
But then they end up in this situation Commissioner Baker's talking about, where it's 72 hours is so tough because we don't know when to start counting it, or maybe we start counting it from the bank statement.
Or over the limit electronic contributions directly into the account are in the 14-day return bucket, if you will, and a check that's clearly over its face that is handed to you is in the 3-day return bucket. That's one. I mean, there's lots of permutations, and I want to wait for staff to come back and think it through for us. But I could envision that being one permutation.
Another thing that could go in that bucket, and because I've never seen the remit envelope, but I just, they sometimes at fundraisers they'll have just forms that you fill out where you just write down your credit card number. So it'd be the similar thing. That could count as a 3-day thing, I guess. Yeah. Anyway, okay. Maybe you didn't want to be that precise.
I saw one detail that might be clarifying that I don't think I mentioned during my presentation.
Clarifying details.
Okay, so in the statute, the subdivision B, which permits a committee to have 72 hours with actual knowledge, the third prong of that is that the committee does not deposit or allow the contribution with actual knowledge that the contribution is more than 2 times the applicable limit. And so, someone brought up whether there should be an amount connected to it. I just wanted to raise that as a clarifying detail, that there is in statute at least that amount, if that's assuages anyone's concerns to any extent.
Right. Thank you, Mr. Lewis. Any other questions, commentary, deep thoughts for Mr. Lewis? All right. Let me call public comment. Is there any public comment on item 6? This is our pre-notice discussion of proposed amendments to Regulation 18531, return of excess contributions. All right. Hearing and seeing none. Whoop, sorry.
I'm sorry, I apologize. Is this something that would be appropriate for an interested person's session, or I know we said outreach, but I'm curious from a procedural point of view, Council Bainbridge, if you think that's the case.
I would say, I mean, anything's appropriate. Whether there will be sufficient interest to justify having it is another question. We didn't get any comments on it this time around. Maybe this conversation will spur some more comments from
For the outreach, yeah.
Yeah. So maybe it's something we have at a law and policy meeting next month and encourage participation from the public at that point would be my suggestion, I guess, rather than setting another meeting.
Thank you.
All right, that works. All right. Thank you, Mr. Lewis.
Great. Thank you all for your time.
2 months.
Sounds good. Thank you.
All right, let's go ahead and proceed to our legislative update, and welcome to the table our senior FPPC Legislative Counsel, Ms. Nakano. I hear you've been busy, Ms. Nakano.
Good morning, still morning, Mr. Chair and Commissioners. I will go over all of the legislative updates to date. Before I get into all of the bills, I wanted to update the Commission on a recent oversight hearing held by the Senate Elections Committee. The committee looked into the issue of the lobbying audits required under the PRA. As you may know, the Act requires that 25% of lobbying firms and lobbyist employers be selected for audit every 2 years. And the Franchise Tax Board is the agency that's responsible for conducting those audits. Over the last several years, the number of lobbying audits completed has reduced significantly, and the Senate Elections Committee held an oversight hearing to inquire into the status of those audits and why so few are being done. According to FTB, they have workload and resource challenges and do not have enough staff to fulfill their PRA audit duties. The Commission was also asked to participate in the hearing, and I testified as to the importance of these audits to proper enforcement of the lobbying requirements. One of the original writers of the PRA, Bob Stern, also provided testimony at the hearing and suggested as a potential solution that the Commission take over these audits. We are continuing to work with the Senate Elections Committee and the FTB on next steps, and I'll keep the Commission updated with any developments.
Thank you, Ms. Nakano. And just wanted to say, I also very much appreciate Senator Glazer and his leadership on bringing some attention to this issue. I think it was 2019, 2020, relatively early on in my tenure, we had FTB come and talk about the challenges that they have. And so certainly an important issue for enforcement of the Political Reform Act, and look forward to seeing what legislative solutions may flow from that.
Thank you. Okay, I'll move on to updates of the FPPC's priority bills. After discussion on these bills, I'd like to ask the Commission for a vote on whether to formally support the Commission's priority bills only. The elections committees are beginning to hold hearings, and the Commission's vote of support will allow me to testify and express that position at those hearings. In fact, SB 29 on the Political Reform Education Program will be heard in the Senate Elections Committee next week. Since the last Commission meeting, 3 bills have been introduced that include Commission-initiated proposals. First, as I mentioned last month, Assemblymember Valencia will be authoring the Commission-initiated bill that would require electronic filing of statements of economic interests. That bill is AB 1170. It was introduced February 16th. It's currently a spot bill, but will be amended shortly with the substantive provisions. Second, SB 678 was introduced by Senator Umberg, also on February 16th. The bill includes the proposal that would require a person who is paid by a committee to post content online supporting or opposing a campaign to include a disclaimer stating that the person was paid by that committee. And third, just yesterday, so it's not on the written report, the Senate Elections Committee introduced a committee bill that includes the Commission's minor and cleanup changes, as well as the proposal to increase privacy and security by allowing redaction of bank account numbers and the street name and building number of addresses listed on campaign statements. That is SB 888. It's a brand new one as of yesterday.
Both of the redaction of private information and the minor changes, are you saying that that's in one vehicle?
Yes, all of those proposals are in the same bill, a committee bill.
Thank you.
Okay, last on the Commission's priority bills, I have an update on SB 29 by Senator Glazer. That's the bill that would codify the Commission's political reform education program. It would also allow the Commission to charge a fee for participation and would require waiver of the late filing fee for participants who complete the program in relation to that late filing. The bill was amended on March 9th to add Senator Ochoa Bogue as a co-author and also to add one of the Commission's minor change proposals to require waiver of the late filing fee if the filer was seriously ill or hospitalized. And this addition doesn't relate to PrEP, of course. However, since the bill was already amending the late filing fee provision, Senator Glazer agreed to take this additional change in the bill instead of the committee bill. And I'll pause here for any questions or discussion on the Commission priority bills.
All right. The bills and the vehicles as they exist today, that as I understand it, you're asking us to vote to support, those substantively reflect the aspects of each one of those proposals that the Commission previously was briefed on and directed you to go out and get authors for, right? There's no hidden, for lack of a better term, or additions to those that we may find objectionable in your judgment?
I think that's correct, with the exception of AB 1170, which is still a spot bill.
Right. Okay. All right. I just wanted to clarify that. Commissioner Baker?
Thank you. It's important because I think in our past, our process has been at the Law and Policy Committee before it comes to the Commission suggesting that we endorse or support bills. We usually goes to the committee. We did not have a March meeting, if I remember correctly. Did we have one in February?
Yeah.
We did. Okay, thank you. Time, space, continuum there. And so we haven't done that in this case, where often that would be the case. So I'm going to ask a few more questions that I probably would have asked in Law and Policy at that point. Going back to the Data Act, by the way, I do want to say I really appreciate the format that you have where you mention, existing law and here's the new part. That was super handy. So I thank you for that format and love it in the future. I just want to distill it down to how this is different from last year's effort or the last session's effort that did not make it out of appropriations, both for the public and my own purposes. If you could hit that again, please.
I think that the main difference between last year's bill and this year's bill is who is required to submit that information. We are continuing to have discussions with stakeholders on this, but last year it was the platforms themselves that had to submit the information to the Commission. This year, in the bill in its current form, requires committees to submit that information. But again, we are having conversations with stakeholders as to what the most appropriate approach is.
And if I remember correctly, was that the original form, and then the proposal, I'm looking at the chair, the proposal went back to the platform people themselves to do it. And so we're basically, this provision in its current form is reverting back to the original proposal that may have come out of the task force. Is that a fair representation?
That's right. Yeah.
I think that's fair. I think another way of saying it is we're introducing a version that is similar to the version that we introduced last year, and again, seeing where it goes in the legislative process. And last year, it went through all the policy committees just fine. It was appropriations.
Yeah, appropriations, yeah. Well, there's always a story behind experience behind that, but yes. Okay, so I appreciate that on the first bill. And you mentioned that it's SB 888 is a committee bill.
Yes.
we had talked about, I think in law and policy and otherwise, a cleanup bill of our own. Is this one and the same? Or
Yes.
how does that relate to our efforts on that?
So our all of the proposals that we put together, that both cleanup and the minor changes, they are included in this new bill, SB 888, along with another one of the Commission's priority proposals relating to privacy matters for candidates on campaign statements to redact bank account information and the street name and building number
Okay.
of their addresses.
And that one's in form now. It's not a spot bill that, you know, the content will be later. You have been able to actually see language so far in the community bill. Gotcha. Okay. I think those are my questions. Thank you.
Thank you, Commissioner Baker. Commissioner Wilson?
Yes, excellent presentation, Mr. Cano. Just a quick question, and I'm making an assumption here, but as kind of a follow-up to Commissioner Baker's comments and questions, with the exception of the spot bill, I'm assuming that any commission-sponsored bills, if there are substantive amendments, that you'll come back to Law and Public Policy Committee and, you know, raise those issues so that the full commission can then decide whether we continue to support that particular measure.
Yes, thank you for that reminder. I will do that.
That was my assumption, but just for the record, I want to clarify that. Thank you.
Any other questions for Ms. Nakano? All right, Ms. Nakano, can you just briefly, which bills and just the numbers are you asking us to vote up or down to support?
Okay, those bills are AB 868, SB 29, SB 678, and SB 888.
So 4 bills. Okay. Well, at this point, then I would make a motion. Commissioner Baker?
I'm going to try to save us a procedural problem. That is why I am interrupting you. So I apologize for doing that. If we could vote on those separately, and I want to give full transparency to my colleagues. As they may recall, last year when the Data Act came up, I had reservations about the requirement on committees. I'm open. I know what a high priority this has been, the transparency part of it, and certainly for the chair and the Digital Transparency Task Force. I intend to abstain on supporting that bill today, as I did, I believe, last year. I might have even opposed it last year. I have to go back and remember. But for that reason, to make life procedurally simple, I want to save us the trouble of motion issues and suggest we do at least that one individually, if you don't mind.
Appreciate that. So how about this? I'm going to move that the commission support Assembly Bill 868.
Okay.
Is there any public comment on that?
Can I second it or no? Do I not?
Yes, please.
I'll second it.
That's even better.
Can we get just for the record clarification?
Yes.
On what AB 868?
AB 868 is our Data Act bill relating to creating a public record of online ads in the state. I can go over a little bit more if it will help.
Sure, go ahead.
Okay, happy to do that.
I mean, I recall the prior discussions, but just for the record.
It's been a little while since we talked about it. So more specifically, the bill would require a committee that pays for a digital advertisement that appears on an online platform, so Facebook, Google, those kinds of things, to submit to the commission a copy of the digital advertisement and information about the ad, including or information about the committee and the ad, including the name of the committee, the name of the candidate or the ballot measure that appeared on the ad, the platform the ad appeared on, the amount that was paid, that kind of information. And they would have to submit all of that to the commission, and the commission would keep that in a public record that would be accessible for folks to search and view.
So my question is, how cumbersome would that be in terms of commission? And maybe you can't answer this question in terms of staff resources that would have to be allocated. If this measure were to pass.
We did have a budget. I think we had a budget analysis from last year. It might have been for the platform approach, so I don't know if it is still accurate for today's bill. but I think in the commission's determination, or at least staff's determination, thought it was not overly cumbersome.
And as a reminder, I know you mentioned this last year, I think, and Commissioner Wood knows because we heard about this at the Transparency Task Force. There are local jurisdictions that are doing this already. And nationally, there are other states that are also looking at this as well as a primary means of addressing the issue of, mistruths, if you will, untruthful statements in political advertising without going too far and trying to censor those things. So it's a way of creating more accountability.
Sorry, just a second rationale that is less kind of, around truth, is that it helps with transparency because these things persist and they can show up during the electioneering windows and things like that. And so or the electioneering communications windows. And so we just want to make sure that people can actually access them and know more about them. The things that they see online that can kind of float by and then reappear without as much disclosure and disclaimer as you might think they need.
No, I understand what the intent is, but I think if I were to support this, us sponsoring this, that we need to closely monitor this bill as it moves through the process, just to make sure that it continues to capture the initial intent.
Yep, that's a fair point. Commissioner Baker?
Thank you. I appreciate my colleagues' good questions and observations. And if it helps, again, because we did not quite go through our usual process of deeply vetting before coming to the commission and doing a vote for support, I am not proposing this today, but I would like to know. So you've got committee hearings that are coming up. Before our next, are they before our next meeting? At least law and policy meeting, but certainly full commission meeting, so that if you don't have input from us, the most you'd be able to testify is where, we did this last year and we're watching it, or would you be not able to provide testimony on this bill when it comes up in the policy committee? I guess I'd have to look at the deadline you put in front.
The only committee hearing that's currently set is one for next week. The only one of our bills, the commission's bills that is on that is the political reform education program. So it
looks like the April 28th is the last day for policy committees, and usually the last 2 weeks before that is when the frenzy's happening. I'm not proposing this today, but I'm offering it if there are questions about it.
I appreciate that.
Yep.
I want to take a step back. Several months ago, you came to us and outlined each one of these ideas to the commission, right?
Correct.
And this one you've outlined, I've lost count how many times, to the commission. And I appreciate your ongoing objections philosophically to this for other reasons, right? But we have consistently voted to ask you to spend time writing the language and going out and getting an author. And today you're just asking us to reaffirm that we support you doing that, right? So I appreciate, we'll vote on this separately. You can register your objection, but I also think we just need to remember the context of this today. So we have a motion, we have a second. If there are no more questions for Ms. Nakano on this, I think at this point we ought to proceed to a vote. Ms. Linker?
Commissioner Baker?
Not voting.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Madge?
Aye.
The motion passes.
All right. Let's move then to SB 29. I will move that we register our support for SB 29.
Second.
Do I have a second?
Yeah.
All right. Any public comment? Hearing none. Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Madge?
Aye.
The motion passes.
Moving to SB 678, I will move that we register our support for SB 678. Do we have a second?
And just-
Second.
Oh, I'm sorry. By way of reminder, this was the third-party posts.
Correct.
Thank you.
Second.
Any public comment? Hearing and seeing none. Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Madge?
Aye.
The motion passes.
Last but not least, I move that we register our support for Senate Bill 888. Do we have a second?
Aye. Yeah. Second.
All right. Any public comment? Hearing and seeing none. Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Madge?
Aye.
The motion passes.
All right. Thank you. Ms. Nakano, please continue with your report.
Thank you. I will move on now to other commission-related bills. There are two new bills since last month. SB 681 was introduced by Senator Allen on February 16th. For some background on this one, the Political Reform Act provides special requirements for amending the act. It provides that the act can be amended by statute to further the purposes of the act if it's passed by a 2/3 vote of each house, and if the bill is delivered to the commission at least 12 days before passage in each house. Functionally, that latter provision means that the bill must be in print in its final form for 12 days before either house can vote on it. SB 681 would reduce the number of days that a PRA bill must be in print before the legislature votes on it from 12 days to 5 days. Historically, the number was even higher. The original Political Reform Act in 1974 had a 40-day requirement. The number was amended in 1976 to 20 days, and then in 1985 to the current 12 days. The purpose of SB 681, according to the author, is to address the situation where, at the end of session, the Appropriations Committee wants to amend a PRA bill, but given other legislative deadlines, there is not enough time to amend the bill and then wait 12 days before voting. We are in discussions with the author's office on the bill about how to strike the appropriate balance between addressing the situation that they describe and also ensuring appropriate public notice and opportunity for the commission to comment. Any questions on this one before I move on?
Questions for Ms. Nakano on this bill? Commissioner Baker?
Are these, I mean, I'm assuming it's calendar days referring to, are the legislative session days or that? That'll be something I'm sure would be pinpointed in the legislation. Calendar. It's definitely calendar. Okay.
Yeah.
Thank you.
Any other questions on that? All right. Do you know, are there particular groups that are supporting this bill, like stakeholder-wise? I'm just curious. Is there any sense of that?
I believe the California Clean Money Campaign is in support of this change.
Okay. All right. Thank you. Why don't you go ahead and continue?
Okay. Moving on, the second new bill is SB 724 by Senator Glazer, also introduced on February 16th. The bill would require a person to file a new report if the person makes a payment or promises to pay or receives or is promised a payment over certain threshold amounts for a communication that, 1, clearly identifies an elected state officer, 2, was made with intent to influence the officer or public opinion, and 3, was published within 150 days of an election. The report would be due within 48 hours of the payment or promise to pay, and would have to include general information about the person paying or receiving the payment and the amount of the payment. There is existing law in the PRA that requires reporting before an election. However, it does differ quite substantially. Existing law requires reporting when a person pays over a certain amount for communications that clearly identify a candidate for elective state office, where the communication does not expressly advocate the election or defeat of the candidate. Whereas this bill, SB 724, it requires reporting for a communication that identifies an elected state officer. So this person is not necessarily a candidate on the ballot. Any questions or comments on this bill before I move on?
Questions, Commissioner?
Just have a comment. I like it. That's my comment. I mean, I really see the scenario where and it's come up before in my time here on the commission, either in stipulations or just ads that I've seen that don't use the magic words of vote for this person, don't vote for that person, but they are effectively having exactly the same effect, and they have it's basically like a loophole. And I like that. I was very pleased when I read this, that this is something that looks like we're at least beginning the conversations of fixing. And so I just want to put that in there as encouragement, as I'm sure you'll continue to talk with the author about what's going to happen with this. But that's what's coming to mind when I see this. So that's my comment.
I agree with Commissioner Baker. All right. Please continue, Mr. Connor.
Okay, thank you. I have some additional updates about some of the other existing bills. AB 83 prohibiting contributions and expenditures from foreign influenced business entities was heard in the Assembly Elections Committee this week. It passed out of that committee 5-2. AB 319, which relates to the Conflict of Interest Code of the Department of Housing and Community Development, was amended. Previously, staff determined that the bill amended the PRA by reference, but after the recent amendments, we believe the bill no longer does that, so we will be removing the bill from the legislation report moving forward. SB 251, prohibiting an elected officer from being employed by another elected officer with the same constituency, was amended to apply the bill only to employment that commences after the effective date of the bill. I think that answers one of the questions that the commission had about this bill. I'm continuing to talk to the author's office about those other questions and to work through what language would be appropriate to address those. Last, SB 409, requiring candidates to write their candidate ballot statements in person and creating a pilot program for including QR code links to candidate video statements in the ballot pamphlet, was amended to add that the in-person writing requirement is subject to the requirements of the Americans with Disabilities Act. It also adds that when a candidate writes their statement in person, they are not allowed to bring in any outside materials. That concludes my update, but happy to answer any questions or
Any
discussion.
questions for Mr. Kano?
Thank you. This goes to one that is in your report. It's on page 5. It's AB 37 regarding use of campaign funds for security systems and personal security. And looks like this is congealed even more since we probably last talked about it. So I did have questions about it. And I remember one that we did ask in either full commission or law and policy was, is there any requirement of reimbursement after the candidate is no longer in office? Or I would expand that to after they feel like there is no security issue. And the same now, since I see this has staff, if there is requirements, sometimes staff leave. And are there any requirements of reimbursement at some point in the future? Number one, that's my first question.
The bill does not explicitly have any provisions relating to reimbursement. I'm not sure if there are any general provisions under the Act that would apply in this case, but the bill itself does not address that.
And this may require a little bit of homework, but I remember vaguely that if once somebody's done in office and they maybe close their committee, if they have things of value that they purchased with committee funds, that they have to it's going to become personal use. Say it's a refrigerator from your campaign office, for example, or something like that. They might have to reimburse the committee for that. I may be wrong, but I'd like to know what those rules are and raise that and potentially with the author in terms of being consistent, since security systems can be quite of value, and there are rules on this already that we have in the books. So that would be one thing that I would just take a look at. The other is raising the question about staff as well. I mean, I know that staff can face threats just by virtue of the work that they do and the authors that they have, but I would be interested in more discussion about that because, people do leave and they might be there for 3 months and get a security system and then leave. And they may move out of state and now the house has, and that adds value to their home potentially. So I think it's important to look at those issues. Thanks.
Sticking with AB 37, I think when we talked about this before, we wanted to get more information from the author on the specific problem with the current statutory and regulatory regime for purchasing security systems, so that we can be more narrowly focused perhaps on trying to solve those particular problems. Do we have that information yet from the author's office?
We do not.
Okay. All right. Yeah.
Sorry, I had one more I noticed in my notes. And we're talking about personal security, not just security systems, if I remember, just by looking at the language. So maybe it's a bodyguard or something. And if there has could be any conversations again about narrowing this down to either an expense, maybe it's up to a certain amount that is going to be allowed for campaign purposes, or for some types of securities, not others. I'd really like to hear more in that regard. Elected officials can really face some terrible threats. They also are, at least state legislators, the CHP is part of our security team. I had threats, so they came and did an assessment of my house and my office and made recommendations. And for some things that I went to, they would be there because they knew there might be they had a concern. And I just want to see are mindful that this could be quite a large expense from campaign funds that the candidates hold in trust for the purpose of office. So I want to add that. Yeah.
All right. I had a question for you on a different bill, AB 83. So the Foreign Influence Business Entity bill. Is there any definition of who a foreign principal is? Like, could that be just somebody here in California, right, who has dual citizenship? Would they be considered a foreign principal?
I think existing law defines foreign principal. There is a particular definition that would apply in this case. I'd have to pull up that language.
I'm just curious because as I understand this, if you are a person who fits whatever the definition is that you're looking up of foreign principal, then if you're a business entity and you have a foreign principal among your partners, you can no longer contribute. Now I know that's an oversimplification because there are some standards here, but there's not many standards there. So I'm just curious.
So it is defined, and the bill adds to it, but it's defined in current law to include a foreign political party, a person outside of the U.S., unless they are a citizen of the United States, or I'm trying to summarize as I'm reading. The person is not an individual and is organized under or created by the laws of the U.S. Okay, well, there's some exceptions that apply there. Foreign principal also includes a partnership, association, or other business entity, combination of persons organized under the laws of or having its principal place of business in a foreign country. It includes a domestic subsidiary of a foreign corporation under certain circumstances. And then the bill adds that it also includes a business entity in which a foreign principal or a foreign government holds, owns, controls, or otherwise has directly or indirectly acquired beneficial ownership or equity or voting shares in an amount that is equal to or greater than 50% of the total equity or outstanding voting shares, if that helps.
I think it does, because is it your understanding then that it would apply to somebody who has dual citizenship?
It exempts a person if they are a citizen. So dual citizenship, I think they'd still be considered, a citizen of the U.S. So I think in that case they would be exempt.
All right. It's interesting. I will tell you, I have some concerns that it seems to be so broadly written that it may have an unintended consequence of cutting against efforts I know the state is making to improve diversity, equity, and inclusion in corporate boards and in all sorts of scenarios. And so singling out foreign principals, I have some concern. Now maybe those concerns are assuaged by that definition. I don't know, but that's certainly something that I'm interested in following as this bill progresses. Any other questions or comments for Ms. Nakano on item 7? Ms. Nakano, anything additional you need from us?
That's all for me today. Thank you.
All right, thank you very much. All right, we'll go ahead and proceed then to item 8. This is a report back from our Chief of Administration, Ms. Hahn, on ADA compliance issues.
Good afternoon, Chair and Commissioner. I'm here to provide an update on the ADA implementation that we have previously updated back in October 2021. During October 2021 Commission meeting, staff requested to seek authority from the Commission to contract and to purchase license with a Commonwealth software license so we could implement the ADA implementation more efficiently and effectively. And thereafter, we started the effort and we purchased those licenses, and staff began implementation in December of 2021. As you can see in my report, there are one-time implementation costs that I indicated in the table within the report, and there's ongoing costs that we're facing. So I'll go over that in a little bit more detail. So the one-time implementation costs, how we figured it out is that staff have to do the training, the one-time update, watching the video, creating like an ADA template of some of the more document that we use over time, like the form itself, the manuals, and the website information. So that was our one-time implementation cost when we update everything from our website to have ADA compliance. And then at that time, back in October, the direction from the Commission was to have staff only remediate document going forward. So it's only started from December 2021 that any document that staff posts on website will be ADA compliance. And those there's also exception. It's the only exceptions are draft version of forms and manuals. Since we're waiting for comments on some of the forms and manuals, so we will have them ADA compliance once they're in final stage. So during the draft form stage, they're not ADA compliance yet. So those are the only exceptions to the information that's posted on our website. And then the ongoing cost that I've calculated, it would be like the monthly continuing things, like new things that we're posting on our website, such as the monthly agenda items, anything that's attached to the agendas, like our advice, our stipulations, things are coming in every month thereafter, December 2021, that staff have to work on in order to have all those document ADA compliance will be the calculation on my ongoing effort. So, and then I also, in the chart itself, broke up the groups that we started training and doing the ADA remediations. The first group that I have is more of the support staff. And then the next group that we have is the intake as well as educational unit, because they do more of the information that's been posted on the website. And then the very last group is some of the attorneys that prepared stipulations and things in the enforcement divisions. So those are the four groups that I broke up because they're implemented in a different time frame. And then so the costs reflect those period that they worked on. And then the ongoing cost, how I calculate it, is from December 2021 to January 2023, because that's how I did a period of 13 months look back to come up with the cost. So with the one-time implementation cost, we calculated and figured it to be around $60,000. And then the ongoing cost through from December through January of 2023, it's approximately $91,000. And then with those costs, I also came up with it would take one personal year to do those efforts, because that's how it revert back from the cost to a personal year cost for us in the Commission. And then also you can see in the chart itself, it has total hours that require for the effort. So, and I broke it into like different categories of hours that we would have to spend on implementing the ADA requirement. And then in addition, I just want to point out that we try our best to be more efficient on implementing the ADA. So a lot of the we use template, we have to create a template in order to be more efficient. Rather than remeeting every single document, if they're like stipulation, they're the same form, then we would create a template. So the guide would be the basic guide, and the staff would go into the basic guide to begin the work on creating the new letter or new Word documents. And then also, I think Commissioner Wilson was the one that posted a question a while ago, if we work with another state agencies. So in April of 2022, we were invited to participate in the state agency web access community of practice. And that forum is ran by Department of Rehab, where we have discussion and strategies of how to implement it. And then they are also one of the agency recommended the Common Look program to us. And then they also recommend that after we adopted the Common Look program to all the other agency that's out there throughout the states. And in general, I just like to conclude that, of course, implementing the ADA requirement require a large allocation of our resources. As you can see, the hours that we spent on just the one time and the ongoing would require, since we didn't get additional resources for this effort, so some of the work that we normally do would have to take a step back, because we have to do this in order to comply with the law. And that concludes my presentations, and I'm happy to answer any question you may have.
Commissioner Wilson?
Yes. Well, thank you, Chief Hahn. In your presentation, you responded to one of my questions already. So I commend you and the entire team for meeting the needs of individuals with disabilities. I think that's very important. And if someone goes to the FPPC, and then they go over to the Department of Housing, et cetera, there's uniformity. And I noticed that there's the Common Look program. And I'll have to confess that I didn't know what that was, so I Googled it. And it's universally used throughout the country and in various jurisdictions. So I think it's good that we're able to provide uniformity so that individuals don't get frustrated as they deal with different public entities. So thank you.
I had just a clarification for you. The very bottom of your chart, it says there's a line that says total full-time employee, and if I go over, I see a 1, but then it says total staff cost, and it's the 181,919. I think the total staff cost, though, and tell me if I'm wrong about this, is actually the 151, because the 30 is the cost of the license, or am I missing something?
No, you're correct. Actually, that's a typo. It should be total cost, not total staff cost.
That's what I took the intention to be. I just wanted to make sure and draw that distinction. It's 151 in cost, but 30.
No, you're correct, because the 181 included the license costs that we annual subscribe to the license. So the actual staff cost is approximately 151,000.
Right. And that's total. The ongoing staff cost each year, though, is pegged at 91, right?
Correct.
All right. Is there any mechanism that you can tell us about where we can go and try and get additional support from the state to offset this cost?
Yes, I guess we could ask Department, or we could submit a budget change proposal to Department of Finance asking for resources. Now, but it wouldn't be resources that's related only to the ADA implementation. It would be resources of overall, if FPPC has a lack of resources, short of resources, then we would submit one change proposal to ask for that. And part of the proposal would include this additional resources that we would need in order to continue. But because we didn't get any additional resources during the adoption of the bill, so it would be, rather than just looking at it as a single item, they would look at us as a whole agency and go through the whole resource, detail of how much resource we would need as a whole agency for more than just the ADA, but everything else that we do if we lack of resources.
Okay. All right. Those are my questions. Commissioner Baker?
Thank you for the follow-up from our prior times on this. And as the author of the bill, it pains me when you see resources that have to be put into something, but it's really important, especially for an agency that has, prosecutorial rules that could affect your ability to participate in our electoral process. And so I'm grateful for it. I'm grateful for our colleagues to continue supporting it, and for the staff that will be spending time going forward doing this. I hope they feel it's worthwhile. I know how much, I was looking at how many hours the enforcement team, for example, is going to have to spend on this. And I hope they feel it is worthwhile, because we should be accessible to everyone. And so I'm grateful for that. If there's ever opportunities for us to request money to offset it, we as commissioners, with the exception of the chair, are less in the weeds about every budget process, but always encourage that going forward. You just never know when you find those opportunities. So thank you.
Thank you.
I wasn't planning to ask any more questions, but I think the chair raised an important issue, and then Commissioner Baker followed up with it as well. If we're obligated, to conform to ADA compliance, and that covers all state agencies, departments, at some point, and I'm not sure it can be initiated by the FPPC, but perhaps there should be a uniform budget that covers all state agencies, and then based on each agency or department's needs, you're allocated, money for that particular expenditure. Because, here it's coming out of our budget. I'm assuming it's the same with other departments. So that's just a question you might want to consult with raise with some of your counterparts to see, okay, how do they deal with it? And then is there any possibility, the Department of Finance could say, we're going to allocate this amount of money to cover ADA, and based on, each individual department's needs, you get allocated a certain amount from just one pot. But I'm not a fiscal expert by any stretch of the imagination, so just raised as a potential issue.
It's prompted a question in my mind, and so I am mindful of the fact that Ms. Nakano is correctly focused on political reform act bills as our legislative advocate, right? And that's a lot as it is, right? We give a lot, and a lot comes at us, and we have to assess through all of it. And Ms. Nakano does a great job with that. There are other bills, and this is an example of one, that affect all state agencies, right? And so is there a mechanism whereby state agencies in this type of situation are notified that a bill is working its way through? And, I'm just curious, right? Does finance reach out to all agencies or send a blast email, say, this bill is working its way through? Do you see any costs associated with it? Or that just doesn't happen? I'm curious, because it's impossible, I think, for Ms. Nakano to follow every single bill that doesn't relate to the act. So I'm just trying to understand if there's another process I'm not aware of.
With my experience, no, there's not another process that finance would come up reaching out to the department where there's a possible impact of all state agency that gets impacted because certain bills add a certain amount, certain workload to each agency. No, I'm not aware of that.
Thank you. Commissioner Baker.
I'll just add to that. I'm not either. The only corollary or closest thing from my experience is during the appropriations hearings, Department of Finance testifies on and scores it and gives that. Now, it's not that this is going to cost the FPPC this is going to cost Department of Justice that, but they do put a dollar figure on there. So it's I wouldn't quite say it's a needle in a haystack. It's a part of hay in a haystack, and so that then would have to trigger some effort to follow up with Department of Finance and say, hey, how do you, or our own team, Ms. Hahn, in looking at what the costs are. So that would be the only way that I could think of for watching out for bills like this from legislators who have good intent.
Yes. All right. Thank you. Any other questions for Ms. Hahn on the ADA compliance update? Hearing and seeing none. Ms. Hahn, why don't you stay right where you are? Let's move to item 9. And this is your 2022-23 fiscal year budget report.
Okay, I have a short PowerPoint that I wanted to walk you through for this budget. Since the last meeting, most of you have questions regarding the actual chart and the definition of the category within my budget chart. So I figured that per some of the commissioner are interested to know the definition of each of those category. So I did a simple PowerPoint just to walk you through the chart and update those numbers for the chart. Okay, so the first slide, sorry, it will show you the total budget that we received for 2022-2023. So it's $15.1 million. And it should look familiar because it's the same number that we carried it over from the prior quarter. And then the second slide will show you the second quarter expenditure in summary. So I just want to point out that on the very last line, you'll see the total salary and wages and operating expense. It's $15.1 million, which matched the total allocation that we received. And then as of December of 2022, we have spent $7.46 million of that. And that leaves us a balance of $7.7 million for the remainder of the year. And now I'm going to go into each category from that chart. So the total salary and wages was allocated $13.25 million. And then total expenditure is $6.7 million. So that leaves us a balance of $6.5 million. For staff salary and benefits. So that brings it up to the next chart, which is the operating expense and equipment. So overall, we allocated $1.93 million for operating expense and equipment. And out of that, up to December 31st of 2022, we spent $744,000. And then there is a remainder balance of $1.18 million for us to spend for the remainder fiscal, for the whole fiscal year. And then I'll go through each of those categories on the next slide.
Okay. My question was going to be if this would be the place to ask, but you just answered that.
Okay.
So I'll wait. Thank you.
So the next slide is general expense out of the category. So general expense included capital assets purchase, non-capital assets purchase, and other general purchases. So that one category, we allocated $351,000, and up to December of 2022, we spent $313,000, and there's a balance of $37,000. And the general expense category included purchase order of item that's exceeding $5,000, non-capital assets purchase that's under $5,000, and also other general expense which include printing, postage, and office supplies. So usually those costs will come in early of the fiscal year, such as contract that we have to do, and that's why you'll see a small balance because we already moved the money into the contract, and then so you won't see a huge balance because we always do that in the beginning of the fiscal year. And the next slide, you have travel, the category. We allocated $30,000 into the travel budget, and as of December, we spent $11,600, and balance to remain to spend for the rest of the fiscal year, it's $18,000. Travel are allocated for commissioner and staff to travel, which included traveling at the commission meeting, training, and conferences. And I would like to point out that $11,000 is only what we receive when people submit their reimbursement to us. So even if they travel through December, if they didn't submit their claim to us, it has not been accounted for yet.
Hassan, sorry, how many more slides do you have?
4.
All right, let's, if it's okay, Brad, let's pause, take a comfort break. We'll come back and continue with your presentation. Any questions? Close it out from there. Thanks, Hassan. All right, 5 minutes.
5 minutes?
Ready.
All right, we'll go ahead and get going here again. We are on item 9, and this is Ms. Hahn's presentation on our second quarter expenditure report. Please continue, Ms. Hahn.
Thank you. So I'm gonna continue with the next slide, which is the training budget that I went to bring to your attention that we allocated 26,000 to the training budget, and so far till today we spent 4,600, and there's remainder of 21,400 left. And just like the travel budget, some of our staff have taken training through December, but they have not submit some of the remittance to us. So this is only accounted for ones that we pay for, and there's still outlier out there, or other agency hasn't billed us because staff took some of the training at the end of December usually. So we'll see more expenditure the following quarter. Okay, and the next one's the facility. That one's very simple. It's just our rent that we spend for the office. We allocated 687,000, and so far we spent 340,000, and there's a remainder of 346,000. Next slide is the consulting and professional service. I believe this is one of the slides that most of you have question on. So the consultant professional service included interagency agreement, vendor contract, which are like CalHR, DGS, EDD, Department of Technologies, work comms, things that we pay for to other agency for service that they provide to us. And this agreement contract are necessary for our day-to-day operation of the agency, as well as implementing some of the service that our IT do for upgrades. So at the beginning of the fiscal year, we have allocated 539,000 to this category. And till December of 2022, we spent 19,000. And there's a remainder of 519,000. And I'll explain why we have that large sum balance after our next slides, because the next one is the information technology, which we allocated 300,000, and till December we only spent 55,000, and there is a balance of 244,000. The information technology are used to allocate program licensing that's necessary to upgrade or maintain our equipment. Okay, so there is a little bullet points that I enter on the bottom of the slides. So the bullet point is basically telling me and you guys that the two slides that I just presented, which is the consulting professional service and information technology, have a current allocation together of 539,000. And we are in time that we need to replace our our content management on our website. There's a software that we purchase and that we subscribe that manage our content of the website, the layout, the design, and all that stuff. And that's coming to an end. So the project that we need to finance for this upcoming project is approximately between 400,000 to 500,000. And that's why you see the two category, they still have a huge balance because I'm reserving that for that project. And you won't see the charge being go through until this project has come close to actually contracting with the company. And we're working with Department of Technology right now to seek the authority to allow us to go contract out to hire a vendor to do that. And then also to purchase the license for the subscription for us to change the content management system for us. And then that concluded my presentations, and I'm here to answer any question you may have.
So can you, my first question relates to the last thing you just talked about, which is the website. I think you're describing as the website upgrade. So $400,000 to $500,000 out of the combined 839 of the two consulting and IT categories, you're reserving that $400,000 to $500,000. So my question for you is, this is the 2022-23 fiscal year budget. Do we anticipate those expenses going through before the end of this fiscal cycle then?
I am crossing my finger that will go through, because right now it's at the Department of Technology stage. We submitted the request and we submitted the proposal to them. So they have about 45 to 60 days to review and have any question follow up to approve. Once we get the approval, then we're ready to contract and with the vendors and or the license company to purchase those. And then, so once we receive approval, the purchasing portion of it will happen rather quickly because we've been talking to them. It's just getting the Department of Technology approval. It's the longest at this point. So I'm hoping that we'll get it in, because we submitted back in February, and we heard something of it last week, and we provided additional information to them.
So just so I'm clear, you're hopeful that we will both get approval and be able to acquire the contracts for the vendors and the other things we need before the end of this fiscal year, which is June 30th. It's like 3.5 months-ish, right?
Yeah, I'm hopeful if we could get something by the end of this month, like the timeline that they proposed from Department of Technology, unless that timeline slips. So if the timeline is what they proposed and what they suggested, it would be timely to get it done before June 30th of 2022. 2023, sorry. 2023.
And that's great. Hope that happens. What if it doesn't happen? What happens to the balance that is left over that we're reserving from this budget for that project? Like, just help me understand, like, does it carry over to the next budget, or like how mechanically does that all work?
It does not carry to the next fiscal year. So by, I would say April, usually every year we have what we do at end of year purchasing. So if this does not happen by the end of this month, then I would have to move on to see if we could buy additional things for the remainder of the year, such as equipment, furnitures, or things that we would need in order to spend what we allocated for this project.
Okay. All right. Thank you. I appreciate that. Well, any other questions for Ms. Hahn?
Sorry, I guess that presumably means that then if those contracts or whatever happen after the end of the fiscal year, do we put it in our budget request that we still have that, or do we have to start from scratch, or is it like that ship sailed and we're out of luck? Kind of. Ultimately, that's where your question goes.
Well,
too.
Ms. Hahn, why don't you walk us through the scenario in which it doesn't?
What happens next?
Like, what happens next?
If it doesn't happen, then we would have to use the following year's budget to the timing of things. Let's say if it doesn't happen before June of 2023 at the end of this fiscal year, then we would have to look at our next year budget and see if we could afford to spend it next fiscal year.
And you're probably preparing next year's budget already, or anticipating it, because the May revised comes out, the state budget comes up, and is usually adopted by June 15th. So even before the end of the fiscal year, you'll have that done. Okay, gotcha. I don't know that there's anything we can do as a commission to support the expeditious closure of this issue, because it is $500,000 or more. But we wish you well and hope that it will conclude.
Do you anticipate there being any major expenditures or anything else that would be in next year's budget that would make it difficult for us, if we didn't get approval in this year's budget, to reserve that money in next year's budget and continue forward with the project? Like, are there any every other year type expenses, anything that would be in next year's budget that would preclude us doing the same thing we tried to do this year?
I don't think so, because as I mentioned in the previous presentations, that I always budget a plus of 5%. So I always have that 5% reserve just in case, because I don't want to budget till the right on the line. So I always have a 5% cushion for me to play with at the beginning of the fiscal year. So hopefully that 5%, because we have a total of $15 million, and our OE&E is $1.9 million. So 5% of $1.9 million would be would be like trying to do my math here, 100,000. And then we'll have to figure out the contract portion because depending on the implementation also depends when we could get the contract executed. So the implementation portion could also, depending, like I said, timing, it could actually happen in 2 fiscal year because it could happen later on the next fiscal year, and then it would then roll over to the following fiscal year. So it depends on the timing of when we actually get the authority from Department of Technology.
Thank you. Any other questions for Ms. Hahn on the budget? Nope. All right, thank you, Ms. Hahn. All right, well, is there any public comment on item 9 before we proceed? Hearing and seeing none, thanks, Ms. Hahn. All right, let's go ahead and move to item 10, our executive staff reports. And welcome back, Mr. Burton. Anything you wish to draw our attention to in the Enforcement Division report?
The only thing I wanted to highlight is just to remind the commission that we'll be presenting a Enforcement Division update at next month's meeting. That stems from some questions that were raised following our last Enforcement Division update in January. But other than that, my report is as submitted.
Thank you, Mr. Burton. Any questions for Mr. Burton on the Enforcement Division report? All right, thank you very much. Let's move to the Audits and Assistant Division report. Welcome to the table, Ms. Shaw, Chief Shaw.
Good afternoon.
Good afternoon.
My report is as submitted, but I can answer any questions you may have.
All right, thank you. Any questions for Chief Shaw? All right, thank you.
Thank you.
Moving along to the Legal Division report, Mr. Bainbridge.
Just one update on page 11 under G. It has the listing of upcoming regulation projects. We were ambitiously planning on having the Levine Act back in April. This is the 84308 regulations that we discussed last month pre-notice. We don't have updated drafts ready yet, so they're not going to be ready for next month. So our plan is to instead bring it back in May for adoption. Other than that, it's as submitted.
Thank you, Commissioner Baker.
Thank you. And that seems perfectly reasonable, even if it, continues going forward. I do want to ask I think interested persons meeting was going to be combined with law and policy. Was it this month? That might have been part of that aggressive schedule. Can you update us on if and when that interested persons meeting has happened or will happen?
Yeah, my plan is once we have a draft of all the regs that we're happy with, we will then we'll look at the calendar and see when it would make sense to have the IP. We want to make sure we give enough notice to people in the public that they have time to provide adequate time to review it so they can provide their comments. So it'll depend on when the LNP falls, whether it makes sense to do it with the LNP or to do it separately.
Okay.
But once we have that date picked out, we'll make sure to push it out there to interested parties and send out an email and blast and all that.
So because we had a pre-notice discussion last month that was very robust, and the next opportunity perhaps that we'll see again the language that your team's been able to work on and put to paper will be April law and policy potentially. Is that, at least for commissioners, when we might see that? And then April commission, sorry everyone, I'm thinking out loud, April commission meeting will be the opportunity for everyone else to see that, or would the full commission not see that language until May? And that's for adoption.
It won't be on an agenda until May,
Okay.
But it will be on the LNP agenda, and I can certainly circulate it to everybody once we have it done.
I'm just thinking they are so complex, and I'm not looking to have you push it out further, but just mindful that we may have lots of feedback and might not be ready for adoption. Maybe we'll come up with all kinds of things, but supportive of your efforts and all of this. I'm so mindful of how complex it was when we talked about it last month, and I'm just trying to anticipate when it'll be able, once it's on paper, how many times we might be able to see it again. And I think you've answered that. Thank you.
So I just want to make sure I'm not missing something, but we would you're talking about an IP meeting in April, right? And then a May L&P meeting, both of which are public, right? Where the language would be out there for review by anybody, including the commissioners. And then a discussion at the May meeting, potentially for adoption, is the third opportunity to see it between now and then, right?
Right.
Okay. Well, I just want to make sure maybe we can affirmatively send that package to the commissioners because it is complex in nature. But there are multiple opportunities between now and May to engage and get up to speed on what staff is proposing. So, all right. Any other questions for Mr. Bainbridge? All right. Thank you, Mr. Bainbridge. Moving to the Admin and Technology Division report, Ms. Hahn, anything to draw our attention to?
No, I would like to submit the report as is, but to let you know that starting next month, the report will drop off the 2021 and 2022 number, and we will begin the 2022 and 2023 filing season.
Okay, thank you. Any questions for Ms. Hahn? All right, Ms. West, Executive Director report. Anything to bring to our attention?
Nothing to add this month.
You sure?
Oh, I'm sure.
Okay. Can you remind us? I think you're going to be doing a presentation on collections. I think that's coming up next month.
I am.
Isn't that true?
I am going to be with the legal division. We're going to do a joint presentation on collections next month.
And we look forward to that. Thank you, Ms. West. Any other questions for Executive Director West? All right. Any public comment on item 10, the executive staff reports? All right. Hearing and seeing none, we'll come to our final item, commissioner comments and proposed future agenda items. There were two that I wanted to bring to the commission. The first one was in response to Commissioner Wood, and I'm probably going to mess this up, so you need to jump in and tell me. But as I understand it, you had an interest in understanding what rules we currently have which protect donor intent. And were there any gaps that may be something of interest for us to draw our attention to through future rulemaking or potential legislative proposals? And then I was going to add to it, if Mr. Bainbridge, if that was the type of report you're envisioning, I would like him to also provide us with any perspective he may have and the legal division may have about constitutional issues with using protection of donor intent as a justification under modern, what I would just call modern campaign finance jurisprudence. Because I think there's been some change. I know there's been some change on what is permissible justification. So I think we ought to think about that as we're getting briefed on this issue as well. Is that?
Yeah, that's exactly right. Because you don't want to restrict people's speech and association, but at the same time, there's this tension, right? Because the donors may have had one thing in mind, not a specific message, but that you wouldn't spend all the money on, having your cousin as a staff member or something. I don't know, right? Yeah.
Okay.
Although maybe our conflicts rules have already catch something like that. But anyway, there's a, yeah.
All right. So that's the first item. So Mr. Bainbridge, that's for you to add to your busy schedule, perhaps later in the year, to provide that informational presentation to the commission. And we can talk more about the timing of that later. The other item I wanted to bring to the commission's consideration is, in we can just call it the before times, before the pandemic, this commission used to periodically hold meetings at different locations around the state. And so I think there's a benefit to that. We have an opportunity to meet and build relationships with local ethics offices. We have the ability to have members of the public who may not otherwise know what we are, what we do, come and watch and observe, and testify, etc. So my question is, are the commissioners open to that? And if so, I would then ask Ms. Hahn, I think, to make sure that we have budget space to do that, and then maybe the next meeting or the meeting after propose a few potential locations. But I don't see anybody objecting to that as a future topic.
Certainly not an objection. I think that's great. The additional put on there are parts of California. Normally when there's meetings like this, it's maybe Northern and Southern California, but we have an Inland Empire and we have a Central Valley that often get forgotten. And so I want to roll that out there as well. Maybe they all won't be covered. And there's North State, there's difficulties with traveling, but I do want to just encourage that as part of the review when that happens. I think it's a good idea. And that if we were to travel, we try to get the multiple layers of benefit from it. Perhaps there's trainings, there's a major conference that already seems to be gathering a lot of ethics officials and clerks and so on that might be outside of our typical calendar that might be appropriate for getting the most out of the dollars that may be spent and the time and energy on it.
That's a good point. Commissioner Wilson?
No, I mean, I think it's a good idea to look at alternative locations, and I think Commissioner Baker's idea of looking at central part of the state is also a good option. If you know anybody from Fresno, they'll tell you that they're 3 hours from every place in the state, so that might be a potential location as well.
All right. Any other commissioners wish to identify future agenda items? Commissioner Wood, start with you.
I mean, only if it's interesting to you all, but this thing we were talking about earlier about intent to conceal, that right now there's really no distinguishing between intent to conceal in the kind of disclaimer or online or on ad disclosure context versus kind of just the form filing context. I don't feel super strongly about it. I mean, it's something that's mostly in the domain of the enforcement division, but I just wanted to raise it one more time in case it is interesting.
What would be I could envision the enforcement division providing information to us on how they evaluate that factor, intent to conceal, right? It sounds like you want to do something more than that, though. Like, what would the action item be for them to present to us, I guess is my question.
I mean, yeah, I guess it would be first like a walk through how it has been done in the past, but if nobody else thinks if nobody else thinks that maybe there is a difference in the intent to conceal when you're not including a disclaimer versus not reporting to the state, like maybe I'm wrong about my intuition here, but since we were talking about it earlier, I just wanted to bring it up one more time.
Yeah, I think, Mr. Burton, I think we can talk after me. I think it would be useful to, at a minimum, provide some information on how the enforcement division looks at that factor and how you currently implement it, and provide an opportunity for us to have a fuller discussion about whether there's room to maybe tweak that a little bit.
Okay, that's something we can look into.
Okay, all right, so we'll do that at a future meeting. Commissioner Baker?
Thank you. I had a topic as well. It came from our robust discussion of the Travis Allen for governor stipulation on the issue and ballot committees and what candidate-controlled ballot committees, and I hope I'm using the terminology right. Yes, candidate-controlled ballot measure committees, thank you. There was a statement that was made that historically this has been dealt with, and the regs were adopted by this commission years ago to plug a hole in the statute. And also there was reference to this being a regulation that was the violation, but then there's also a statute. So it raised for me the question of understanding two things. One, just understanding better the rules that are applicable to what a candidate can do, someone who's office holder or a candidate and has a candidate-controlled ballot measure committee. And so it's a briefing kind of as a one-on-one, because it's possible that hasn't been done. And we have, hopefully my colleagues don't mind if we have that. I can do it separately one-on-one with someone if that's a better use of time. But the second question is, what does the statute say and what do the regulations say? And since the regulations were meant to plug a hole, it's helpful to me to understand, as this comes up in the future, how we did that. And maybe not revisit, but understand some of the conversations about what issues had to be grappled with for that, because we don't have a lot of comparables. There weren't a lot of advice letters that were relevant. And as I recall, there have been appellate cases specific to the FPPC on where there's been challenges to us on when there's a hole and we try to plug it, that can expose us to court challenge if we go too far. And I would love to know as a commissioner, as we write regulations, both in this context, perhaps in others, what those rules are. And the candidate control ballot measure committee context seems to be a good, tangible place to do that because it's just come to us and instead of doing it theoretically. So I hope those two points be helpful. It is not, in my view, time sensitive. There's a lot on the plate of our legal team for sure. And so if this is something that happens in the next 6 months, or my hope would be it's before we get into the fall where we start to think about legislation in the future and our regulatory calendar in the future, so that if we want to do something to provide clarity, we can be planning for next year. I hope that helps. And then I had one comment unrelated to that.
Yes, it's helpful. And
Thank you.
I think just to put a point, that is something that will be also in Mr. Bainbridge's bucket. And maybe late summer would be a good time for. I flipped back to the upcoming regulations project.
There's a lot going on.
There's a lot going on the first half of the year, so we should later in the year.
I appreciate
but your
that.
point is good on about.
Yeah, and that's because towards the end of the year, our great legislative team is already anticipating what will come next. Legislators are anticipating what they're going to do next year, and so if there's an opportunity for us to work into that. My second one is completely unrelated to this topic, and it's a comment. And I know that we cannot substantively discuss something raised during the meeting, and I hope this isn't. Mr. Banger is going to tell me if I'm going outside those bounds. Commissioner Wood asked a great question during our SB 1439 discussion last month about how hard is it for candidates to keep track of their contributions, and is it? If I remember, I'm looking this time, and I remember chiming in on that, thinking, well, maybe it's not that hard. It says in our minutes, and I've been thinking about that question for the last month, and I know that we give feedback to our team as they're writing these regulations. So if it's permissible for me to do that here, it could be very, very complex to keep track. And we touched on some of those topics in a different context today. When you have hundreds of contributions coming in all at once, both electronically, and you've just had an event that day. So I tried to relive my life as a candidate way back when, and I revised that there are tools available to candidates and treasurers to do that, but the volume of contributions that can come in a short period of time can be significant, and we need to be so mindful of that here. So I just wanted to add that if it's allowed at this point, and I've already done it. So there you go.
The record reflects your reflection and commentary to staff. We will not redact that. No. All right. Anything further for closing comments or future agenda items? Commissioner Wood?
I really appreciate that. I just wanted to add that I don't think my stuff's particularly time sensitive either. I know everybody's very busy, but to the extent that one of them seems promising, I would guess it might be the duties to donors in terms of for the legislative calendar and things like that. But anyway, I don't want to put pressure on anybody. Sometimes I feel like the things that are interesting to me may not be interesting to other people. So
no, I think it is good, and I think it is useful for the commission to periodically have informational briefings to help us do what we're doing every month. So I don't ever feel bad asking for more information, in my opinion. All right. All right. If there's nothing further on item 11, then do we have a motion to adjourn?
Move to adjourn?
Second.
All right, Ms. Linker.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Madge?
Aye.
The motion passes.
All right. Thank you, everyone. Great job, and we'll see you next month.